So welcome everyone. We will now continue with the remaining questions of polity. So let us look at question number 11 over here. Consider the following statements. Pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act 1971 was passed. So this was a factual information, but this is a correct statement. Okay. Then the Constitution of India empowers the Supreme Court and the High Courts to punish for contempt of themselves. This statement is also correct. If you look at Article 129 of the Constitution, it empowers the Supreme Court to punish for its own contempt. Article 142 clause 2 of the Constitution, again it empowers the Supreme Court to punish for its own contempt. And Article 215 of the Constitution, it empowers the High Court to punish for its own contempt. Okay, these two courts, they are the court on records. Then if you look at the third statement, the Constitution of India defines civil contempt and criminal contempt. Now this statement is not correct. If you look at all the articles where contempt of court is mentioned, they have not talked about what is the nature of contempt. It has not been defined. So in these three articles, there is one more article where contempt of court is mentioned in the Constitution. It is Article 19 clause 2. Okay, the restrictions to Article 19 clause 1a, that is the freedom of speech and expression. There also they have provided that if any law is made for contempt of court, it can violate freedom of expression. Okay, so it is not defined. Then if you look at the last statement, in India the parliament is vested with the powers to make laws on contempt of court. Now here you need to just think over it. If you look at Article 142, in Article 129 and Article 215, they have not clearly mentioned about the parliament, but Article 142 very clearly they have mentioned, subject to any law made by the parliament, the Supreme Court can punish for its own contempt. So unless there is a law made by parliament, Supreme Court can exercise its powers, but the parliament has been given the power to make a law. Similarly, Article 19(2), if you read, there also the wordings are very clear that if the state makes a law to provide for contempt of court, then that can breach fundamental right under Article 19(1)(a). So this statement is also correct. The parliament does have the power to make law for contempt of court. So statements 1, 2 and 4 are correct, and the third statement is the incorrect statement. So option B is correct. Okay. Now let us look at the next question. With reference to India, consider the following statements. The first option, government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. So if you look at the first statement, government law officers and legal firms. So even if you are not aware of the Advocates Act, even if you don't know legally, but just by common sense also, legal firms, they are not covered under the Advocates Act. Okay, we know that there is an Advocates Act which defines who are advocates, section 2 of that act. Okay, section 2(1). So legal firms are not advocates. Government law officers, again, they are not advocates, all of them. There are officers who are just having some law degree and they are giving some legal opinion to the government. So government law officers and legal firms are not advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. So this statement is not correct. It is incorrect. Then bar councils have the power to lay down the rules relating to legal education and recognition of law colleges. This is a correct statement. Bar Council of India is a statutory body which is laying down the standards of legal education. Every institution which is providing legal education, it has to be affiliated with the Bar Council. It has to be getting the benchmarks set by the Bar Council. Otherwise, the Bar Council can cancel their recognition. So this is a correct statement. So if we look at the options in the question, option B, 2 only will be the correct answer. Okay. Now let us have a look at the next question. Consider the following statements. Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. Now if you look at Article 76 and Article 88 of the Constitution, These are the two articles where we find references to the Attorney General. Article 76 talks about the Attorney General, and 88 provides with the rights to certain members, certain people to attend the meetings of the Parliament. So Attorney General, being a constitutional body, has been explicitly given powers through Article 88. But if you look at the Constitution, there is no mention of the Solicitor General of India, and legally also the Solicitor General of India has not been provided with the powers to sit in the meetings of the Parliament. So this statement turns out to be incorrect. Okay. Next, according to the Constitution of India, this statement is incorrect. According to the Constitution of India, the Attorney General of India submits his resignation when the government which appointed him resigns. Now, if you look at the Article 76 of the Constitution, which provides for Attorney General, what does it say? It very clearly says that the Attorney General holds his office till the pleasure of President. Okay. Now, pleasure of President is dependent upon whom? It is dependent upon the Council of Ministers. Okay. So, legally the Constitution does not require the Attorney General to resign when the government resigns. Okay. It depends upon him. By convention, because he is a political appointment, he resigns when the government resigns, because he was appointed as a political position. Okay. But Constitution does not require it so. So the statement is not correct. Okay. So the options, if we look at, D will be the correct option, neither 1 nor 2. Okay. Now the last question, with reference to the writs issued by the courts in India, consider the following statements. The first statement, so we know that writs are issued under Article 32. Okay, there are 5 types of writs, all are issued by Article 32. Mandamus will not lie against a private organization unless, so what are the key words? Private organization, unless it is entrusted with a public duty. Okay, so what is the statement saying? It is saying that mandamus is not issued against a private organization unless it is entrusted with a public duty. Now this question, to understand it, you also need to have idea of Article 12. Okay, what does Article 12 talk about? Even if you have not gone into the details of what is mandamus, if you just know that mandamus is issued against the state, okay, if you don't know the nitty-gritties of it, if you just know what is the state, you can get this answer, isn't it? Article 12, the definition of state, you must be aware that there are certain bodies falling under the category of other authorities. Okay, so any body which is doing anything which is related to government or doing something of public duty, something of that sort, it can be covered under the definition of state. Khalid Mujib case, if you must remember that. Okay, so this statement is correct, because a private body, if it is entrusted with a public duty, it becomes of the nature of the state. Okay, mandamus can be issued against the state. Then second statement, mandamus will not lie against a company even though it may be a government company. Now this statement is incorrect. Okay, it is exactly opposite. We have just discussed that any body, even if it is private body, okay, if it is having a public duty, if it is doing something which is like the state, it can be called the state and mandamus can be issued against it. Now here it is very clearly saying that it does not lie against a company even if it is a government company. So government company is very clearly, it falls under the definition of the state under Article 12. So this statement is incorrect. The first statement was correct. Let us look at the third statement. Any public minded person can be a petitioner to move the court to obtain the writ of quo warranto. Okay. Now this is again something which is very straightforward. What is the writ of quo warranto? Okay. Mandamus is issued when some public body, the state is not doing something, you want the state to give some order. So there you have to go personally. In quo warranto, any person, if he finds that somebody who is holding a important public office is not qualified for that, you want to question the authority of that person, by what authority he is sitting in that government chair. Okay, suppose somebody is MP, etc. You want to know by what authority he is sitting in that chair. So any person who is having interest in public, any public minded person, more or less like a PIL, okay, so they can be a petitioner to move the court to obtain the writ of quo warranto. The court will not ask why you are coming to us with this question, whereas in the other writs except habeas corpus, all the writs, whether it is prohibition, certiorari and the mandamus, all the 3 writs, they cannot be issued, the court will very clearly ask why you are a party. Here it is not the case, so this is a correct statement. So option 1 and option 3 are correct. Option 2, this it is not correct. So if you look at the options, it is C is the correct answer. Okay. So I hope you have got it now. Thank you.